The Fall 2020 Hinkle, Pryor, and Fisher Parent Empowerment Conference. Realities for a New Reality. 2 days, 25 workshops, renowned speakers and presenters, by families, for families, nearly 40 hours of unfiltered and straightforward information, made possible by the leaders in disability rights advocacy for over 45 years, Hinkle, Pryor, and Fisher, attorneys at law. So welcome to this session of our ongoing encore presentation series of the Fall 2020 Hinkle, Pryor, and Fisher Parent Empowerment Conference.
Good afternoon, everybody, and welcome to the Hinkle, Pryor, and Fisher Virtual Parent Empowerment Conference. I'm Paul Pryor, and I will be your host and your moderator for today on this workshop presented by, I don't know whether to call you former judge or judge, but Judge Larry Jones, Lawrence Jones, and
Just
Joni
call me
Jones.
Larry is fine.
Well, I can call you Larry. That's I always feel weird about calling judges
It's
by
okay.
the first name, but hey. Judge Larry Jones and Joni Jones, who are talking about mediation and divorce in the child with autism. So it's a timely topic, it's a great topic, and unfortunately it's a topic that comes up quite often. Before we begin, a couple ground rules or housekeeping rules to say. We ask that all participants please mute their microphones throughout the session. This workshop will last approximately 90 minutes, and I will be taking questions if time allows. All we ask is that you please ask your questions in the chat feature, in the chat box, in the control bar below or the side, depending on what kind of platform you're using, and I will attempt to answer them, I ask as many of them as I can, time permitting. I do have a lot of questions in advance because this is sort of this is going to be more of a dialogue than a monologue in this type of a forum. But I welcome and encourage additional questions from the participants. And now it's my pleasure to welcome our presenters. Joni Jones is board certified in psychiatric mental health nursing with over 40 years of experience. She has served as a member of the New Jersey State Board of Nursing under 2 governors and was appointed to serve on Governor Murphy's transition team on health issues. She has spoken nationally on issues regarding autism and has served as a court-appointed guardian ad litem and expert witness. Joni was the recipient of the Elizabeth Kellogg Award for Excellence in Mental Health Nursing. She was a certified instructor in mental health first aid and has authored several publications, published articles on mental health related issues. She obtained certification in crisis intervention from the state of New Jersey and served on Ocean County's mental health committee. She is the parent of 2 children on the spectrum, and she was previously served as a mediator in multiple municipal courts. Larry Jones, and yes, they are related. This is a husband and wife duo to talk about divorce and mediation, by the way. But Larry Jones recently retired as a New Jersey Superior Court judge. During his years on the bench, Judge Jones served as the president of the New Jersey Council of Juvenile and Family Court Judges and authored over 60 opinions on novel issues of law, including a significant opinion regarding custody and parenting issues for children with autism, known as Rooney versus Wall. It's a 2015 decision. Following Judge Jones's departure from the bench, he was honored by the New Jersey Law Journal in June of 2017 as a distinguished leader of the New Jersey Bar. And in November of that year, Jones was appointed by Governor-elect Phil Murphy to serve on the gubernatorial transition team relative to legal issues and social justice. Larry has served on both the New Jersey Council on Developmental Disabilities and the Governor's Adults with Autism Task Force in from 2007 to 2009. Both times as an appointee of Governor Corzine. And Larry has had many other leadership positions within the disability community and the bench and bar. Judge Jones is founded and developed and co-presented the first program in New Jersey for sitting family court judges on autism and divorce, which was presented at the New Jersey Judiciary's Judicial College in 2010. And yes, judges do have to go for additional continuing education. Jones also co-authored the 2010 Judicial Bench Guide on the subject and is the co-author of the, quote, Jones-Holmes criteria, close quote, of special considerations for judges deciding custody issues regarding children with autism, which has been presented at the New Jersey Judicial College in 2010 and the Autism Society of America's National Conference in 2013 at the American College of Forensic Psychology in San Francisco. Judge Jones has certainly led the way both locally and nationally, on these issues. Judge Jones has presented and co-produced or produced many different continuing legal education seminars and classes for lawyers on autism and divorce and autism-related issues for the family law practitioner, some of which I've had the honor to be a part of. So thank you for that, Judge. Judge Jones and his wife are the parents, as we've said, of 2 children with autism. Among my favorite of their accomplishments, by the way, is in 2002, their 5-year-old son's journey to play Little League gave rise to professional baseball's first ever Autism Awareness Day, an event honored by the National Baseball Hall of Fame in Cooperstown, and resulted in an event which had their son throw out the first pitch for the New York Yankees. So that's what we call being an impact player, for sure. Following his departure from the judiciary, Judge Jones has been appointed as an adjunct professor of Monmouth University and Montclair State University, my alma mater, Montclair State. So thanks for that. And he presently practices mediation, arbitration, and dispute resolution on a statewide basis. They reside in Toms River, New Jersey. And welcome to the program, guys. Thank you for being here. Obviously, you both know a lot about this on both a personal and professional level. And, as the parents of two now adults, right, with autism, right, are diagnosed on the spectrum, you guys have certainly had a long journey in this gig. And I've actually known the Joneses for a lot of years. I had hair, I think, when we first met.
I had an afro, Paul, at that point.
So, right. So we both, Joni, you're the only one who hasn't aged a bit. So, we kind of wanted to talk about mediation and divorce and the decoupling of the family unit and the unique circumstances and perspectives and considerations that crop up when you have a child with autism. Really, I think this could probably be said for a lot of issues involving any child with special needs. And of course, there are certainly a lot of emotions and issues that arise when any family divorces. And those issues are heightened or exacerbated when you have a child on the spectrum. So I'll let whoever kind of field this one first, and maybe you both have some thoughts. But if you could give some insight on what kind of legal issues arise and how often they arise when you're talking about a family who has a child with special needs and autism in particular, and how the courts address those issues when they arise.
Okay, I guess I'll start. The focus very often in autism support groups tends to be on disputes with school districts. Placement of a child in what's the program going to be, what's the IEP going to be, and those take place. And if there are disputes that go to court, they take place through the administrative law courts, through the administrative law judges. However, when you have a separation or a divorce taking place in a family, and it involves a child with autism who's on the spectrum, those issues very often end up in family court if the parties cannot reach an agreement between themselves. And the issues tend to be custodial in nature, custody, parenting time schedules and how that parenting time schedule can be accommodated vis-a-vis, for example, if a child has a therapy schedule going on, etc., and a whole bunch of other issues and sub-issues that flow from that. Issues concerning child support and special expenses and the cost of special expenses for the child. Other related financial issues concerning, for example, spousal support or alimony, division of assets and debts, which they interrelate to child support. They interrelate to the whole family economic picture. You can't just isolate and say, we're just going to deal with child support and not talk about these other financial issues. Life insurance and setting up potentially trusts and special needs trusts, which, you know, Paul is heavily involved with. And of course, things like where the child's going to live separate from custody. Sometimes you have an issue concerning if a parent wants to move or move out of a district into a different school district. That can create some issues. Issues concerning the autism itself sometimes arise. There could be a dispute between parents as to, number one, if the child even has autism, or if the child has autism, to what level interventions are necessary. So there could be battles between father and mother, or parent and parent, concerning what type of program is going to be in place, who's going to fund the program, what additional ancillary needs are necessary, and so, and how are they going to be funded. So these types of issues come up quite a bit. And on top of that, sometimes when there is an issue going on with the school district, sometimes the school district doesn't agree with the parents, even in an intact family, about the child's diagnosis or interventional needs. Sometimes in a separation or divorce, you have two parents who don't agree with each other on that. And one parent perhaps takes the side of the school district and the other takes an opposite position. And before the administrative law courts can get into all that, somebody has to decide which parent basically has the right to determine what the parental position is going to be. So often that issue can come up in family court first, and then it goes on to administrative law court. The family court doesn't decide what the school's going to do because the school's not a party to a divorce. But if there's a dispute between parents about what the parental position should be, that sometimes comes before the family court by way of application. There could be a whole bunch of other secondary issues, but these tend to be the most common ones. Joni?
Yeah, and I think there's extra stresses that when you're looking at issues related with autism, because we know with the autistic individual that it affects them in their unique way. So their issues and their plan of care is going to be in that unique way. And if you have a judge or a mediator or even an attorney that's not well versed in the general issues related to autism, there's extra energy that has to be utilized in explaining the why of maybe these special issues that may not have ever been addressed previously, since they're not familiar with the particular field. So there may be increased frustration levels and even a degree of fear, because now we're getting into the what ifs, you know, and then realizing that somebody's really not speaking this language. So the experience of the mediator or the attorney or judge will understand generalization, for instance, in parenting, the importance of it. So when they're aware of this, there can be better outcomes based on what the agreements are going to be or the need for additional trainings of the parents, especially if there's a difference in perceptions.
Yeah, and that's why we initiated the autism training at Judicial College back in 2010. It was exactly for that reason, because while courts can learn ultimately anything, you know, there's always new issues coming up and new things which a court may have never dealt with before, a particular judge or even a whole courthouse. When you look at the statistics with autism, for example, in New Jersey, and you look at the statistics of divorce, it's pretty obvious that any court, any family court, if they're around long enough, they're going to come across many cases involving a separation or divorce of children with autism. For example, the CDC last year, they put out an annual statement of the prevalence of autism, and New Jersey is at the top of the list. It's now 1 out of every 34 children are diagnosed with autism. There could be many theoretical reasons for that, but that wasn't a one-time situation. That was also the case the year before. 1 out of every 34 children in New Jersey have autism, and the divorce rate nationally is essentially 50-50, 50%. So you put those two numbers together, it's almost impossible to imagine that a family court is not going to come across many, many cases involving a divorce or separation, if the parents were never married or are married but are just separating at that point, involving a child with autism or on the autism spectrum disorder. Sometimes it's more than one child. Sometimes you have parents who have 2 or more children on the spectrum at different levels on the spectrum. So you can't just lump them all together. You have to look at each child in a unique fashion. So this is why, like Joni says, it's pretty important for courts, for advocates, for attorneys, for the parents. Sometimes the parents don't even have sufficient information on autism, to not fly blind and to really, self-educate and educate and understand. Everyone in the system has to understand what the real needs are for any particular child with autism before you could start planning what the result will be or what the disposition should be.
So we were talking, actually, before everybody else joined, we were kind of talking in the virtual green room, so to speak, before we got started. And we were commenting, and I've been a lawyer for a long time, and Judge Jones is obviously very experienced and has been a judge, both a family court lawyer and family court judge. The court process can be very difficult, and it can be very challenging. And quite frankly, as a young lawyer, I thought I was going to be in court and arguing cases a lot more than it turned out to be the reality. And in reality, cases are often resolved without a judge's intervention, right? And the joke is like, I tell my clients, if you go to court, the last thing you want to do is leave your fate up to some person in a black robe, because they may not get it right. So a lot of times, what we call generically is alternative dispute resolution. And I think that probably the main form of that is mediation, hence the title of this workshop. Judge Jones, I wonder if you could explain a little bit about what mediation is and how that differs from arbitration. And Joni, I wondered if you could talk from a mental health point of view about what are the main benefits of mediation, if any, to the parent, to the child with special needs, as opposed to, full-blown litigation.
Sure. Okay. Well, mediation is a form of what they call alternate dispute resolution, ADR. There's a very strong public policy in New Jersey that has been restated hundreds of times, that the courts, particularly in family court matters, favor attempts of persons trying to resolve their problems out of court, that it's best for them, it's best for the children, for a multitude of reasons. First of all, you tend to save money. Number 2, you tend to save time. Number 3, you reduce the risk, because if you go in front of a judge, there's no guarantee what the result is going to be on any contested issue. Whereas if you go through mediation or a settlement conference, something along those lines, you have some control over the outcome. You are participating in structuring the actual outcome of your case. In a trial, you don't do that. You're just presenting evidence and kind of hoping the court's going to rule in your favor. And sometimes that doesn't happen, or sometimes it happens partially and you get kind of a mixed bag of results and everyone leaves unhappy, depending on the nature of the case. The other point about going to trial, sometimes people say they're just convinced, they just know the court has to rule in their favor and they are proven wrong. But even if they're proven correct, the other side has an automatic right to appeal, you see. So this case can go on and on and on. Your day in court could end up being months or years in court, as the case may be. There's an appellate division. Sometimes even the Supreme Court gets a case. This means more time and money and uncertainty. And so most people like to have some degree of control over the outcome of their case. So mediation is a forum where two people can try to resolve their case. They can use lawyers. So lots of times when I mediate cases involved in mediation, there are lawyers involved. You don't have to have a lawyer. Lots of people represent themselves, but that's a personal choice whether you use a lawyer or not. And sometimes, there's one side which has a lawyer and the other doesn't. So you never, that depends on each person's own particular desire as to whether to bring counsel or not. But like Paul had alluded to a minute ago, when he says he didn't get to court as much as he originally anticipated, the truth of the matter is most cases statistically in the family court, and really in most courts, settle. They settle. Very few cases go actually to trial. Now that they don't settle because suddenly in a divorce, one side wakes up and says, my ex is right and I'm wrong. That never happens. I've never seen that happen once. And I'll never see it. The only person I feel that works with is my wife, who's always right and I'm always wrong. But other than Joni, it never happens. So, but yet cases still settle. Why? Because they settle because it becomes too expensive to go on. It becomes too time consuming. It becomes too stressful. There's a lot of stress involved in contested litigation. Anyone who's been through contested litigation, a sick feeling they get in their stomach when they go out to their mailbox and see the thick envelope from their attorney, knowing that there's probably some typewritten insults about them from the other side or the other side's attorney. They don't like living under that cloud of uncertainty. And also they want to kind of get it done. So in the context of family court, cases do tend to settle, but the problem is when they settle. Sometimes people come right out of the starting gate in a divorce, and even divorces that don't involve a child with autism, in any contested divorce, people have lots of reasons to fight with each other. They've got all this negative energy. They're ready for war. They're not talking about settlement. All they know is they want their day in court and they want to beat the other side, and the other side's wrong and they're right, and they're spending a fortune in money and in time. And then after 6 months or a year, however long they're in this horrible situation, now they're suddenly ready to settle on the courthouse steps or whatnot, which is great, but they could have done a favor for themselves by talking about that early on, before they spent all of this money and all of this time and all of this stress and negative energies going back and forth and beating each other up, and sometimes getting nowhere, both sides. Because the court system, they don't address your issues with finality immediately. Even if you get into court immediately on an emergent application or what they call a motion, the best you're going to get is, in all likelihood, some type of temporary order, what they call without prejudice. It doesn't necessarily resolve anything with any finality. So if a case is going to settle anyway, in the most instances, it makes sense to at least attempt to do it earlier than later. So mediation is one way to do that. So what mediation is, I'm just going to give 2 quick rules on mediation, and then I'll turn over to Joni. But mediation is essentially a forum where you can sit down and speak with the assistance of a third person, neutral person, not the attorney for both sides. The attorneys can obviously participate, but a neutral mediator tries to resolve the conflict or conflicts between the parties. Number one, it's confidential. What that means is nothing which is discussed in mediation, in the event it's unsuccessful, can be repeated by either party in court. The reason for that is the courts want to encourage people to talk openly about different possibilities of settlement, which usually requires some degree of compromise and flexibility and open-mindedness by both sides. If one side goes in and says it's this my way or the highway, well, then look for the highway, because the other side probably is not going to agree. If they were going to agree, you wouldn't be in court. They would have already agreed, right? So the example I used to give to litigants when I was on the bench before settlement conferences, I would say, look, to keep it simple, let's just assume hypothetically 2 people are getting divorced, and wife says to husband, you owe me $1. I'm suing you for $1. But to get this done, to save time and money and effort, I'll take 75 cents. They say this in a mediation or a settlement conference. And husband says, I don't owe you anything. I don't owe you $1 or anything, but I want to get this done too. I'm not going to give you 75 cents, but I'll give you 50 cents. And the wife says no. And they still can't resolve their differences. If it goes to court, the judge is not allowed to know about the 75-cent offer or the 50-cent counteroffer. All the court knows is there's some dispute over $1 that has not been resolved. So mediation is a great place to try to work things out without the risk of it being used against you. That's number one. And secondly, in mediation, an agreement is not finalized until it's in writing, generally, or by joint agreement put on tape. So sometimes people are concerned if they say something in mediation, if they say, well, yeah, I'll consider for example, with a parenting schedule, I'll consider taking less than 50-50 time, and I'll only visit on Mondays and Tuesdays, but I want, half the summer or something like that. It doesn't become locked in until everyone signs off on it. Because sometimes people were concerned that if they say something in mediation and then it's construed as some kind of a verbal agreement, that it could be enforced against them, and it cannot be. And then it will become very difficult because, as I just said before, everything which takes place in mediation is essentially inadmissible for the most part, with very limited exceptions. So if there's some dispute as to whether there was a verbal agreement or not, how could a court decide that without hearing what took place in the mediation? It's like a catch-22. So about 6 or 7 years ago, the Supreme Court said, look, unless it's in writing, it's just negotiation. It's not an agreement. And so some mediation sessions go very quick and they're over and they got the whole case settled in a day. Others take a little more time. They take several sessions depending on the issue. Joni?
Well, I have to agree that one of the biggest benefits is some kind of control over the outcome. I think the compromise is very important, that is focused, because some people will go into a court situation and no matter how right they think they are and what they feel the justice is, that doesn't mean that that's what's going to be the outcome. Because if two people are feeling the exact same way, it can't be both ways. So that knowing that the control of the outcome comes through the compromise. The other benefit is that if there's 10 issues that need to be addressed, you can use mediation and maybe get 8 of those issues resolved. So you'll only have to go into court now for the 2 issues. And if you have an effective mediator, an effective experienced attorneys, usually once they get to the level of those 8, they usually can get to those 9 or 10s. So that's one benefit that I see with going to mediation. The other one is the convenience of a less structured environment. And, wherever there's that structure, it may come with some triggers. Just like when somebody goes into a doctor's office and they experience white coat syndrome and they have the anxiety that causes their blood pressure to go up, or sleep disturbances because it's so structured. Some may have been in a courtroom before, some may never have been in a courtroom before, so they don't even know how to, what to expect or what the transitioning is going to be like. So you have the convenience of having mediation that now you could do it in person, but you also have the convenience of doing it over Zoom. And one of the benefits of doing it online or over Zoom is that you have the comforts of your own home. So whatever those things that bring comfort, it might be an emotional support pad, it might be, the climate control, the clothing that somebody wears, so that, environment becomes very important. Also, you have more flexibility in the scheduling or taking breaks. In fact, Larry can tell you that, they have scheduled around people who had to stop and pick their kids up from school when school was in session, or other things, and they work the scheduling around that. So you have the control of how you're breaking it down. And I think also, being able to be very specific in setting what's called ground rules. So, if something is more contentious, somebody could say, hey, listen, if somebody is going to start, yelling, this is how we're going to handle it, so, there's just more, control of the setting.
Yeah, and I agree with Joni. Zoom really, if you're looking for any kind of a silver lining in the COVID cloud, it's the prevalence of Zoom and how it has really made something such as mediation a lot more convenient for people and a lot more doable for people. Remember that before Zoom, and Zoom's been around a while, it just never caught on until COVID. But when you try to get everyone together under the same roof, first of all, preliminarily, there could be scheduling issues, especially if a lawyer's involved. Number 2, there's a lot of time, kind of waiting around and spending money on that, because most mediations, not all, but most involve some degree of what's called caucusing, meaning the parties are not in the same room at the same time. The mediator kind of goes back and forth, unless the mediator feels it would be beneficial to have everyone come together. So for example, when I mediate cases, I usually start off with everyone together, whether it's on Zoom or in person, just to go over the general ground rules. But then we break into caucuses. So I'm just hypothetically, let's say an hour with one side and their attorney, if they have an attorney, then I switch an hour with the other side. And then we kind of go back and forth and do some shuttle diplomacy. That's especially necessary in cases when the parties just can't sit in the same room together because they just can't. They rub each other the wrong way, or there's some backstory. By the way, if there's a domestic violence restraining order, you can't mediate, and you certainly can't mediate with them together. And even separately, with very limited exceptions under a pilot program for economic issues, you really can't mediate when there's a restraining order. But even if there's not a restraining order, sometimes people have a very, very contentious relationship with each other, and it's not good to have them in the same room, at least not immediately. Then as the negotiations are going on, if it looks like we're getting somewhere and it's productive to have them together, then you can do that. So with Zoom, it's so much easier to be able to do that. Someone's not waiting around for 2 hours while the mediator's talking to the other side. And also there is some, like Joni referenced, stress. You know, when people are in a divorce, as a contested divorce, it's one of the most stressful events in somebody's life. And that could be amplified if they know that the person who they have these really negative feelings about for whatever reason in the past in the marriage or the failed relationship, if they're sitting in the other room. So even if they're not in the same room, just being under the same roof can cause stress to a litigant. So when you're, with Zoom, you don't really have to worry about that stuff as much. And I've personally seen that with Zoom conferences, there is a clear lowering of the tension and stress levels as compared to when, in the old days, so to speak, since last March, when you would do these things in person. You can still do it in person, but there's another option here that I think is going to in time become actually the choice of preference for most litigants, which is doing it online.
So, Joni, I was wondering if you could talk about, perhaps from a mental health perspective, the effect of the litigation, or even in the mediation, on one's mental health, and how that might, if any way, sometimes relate to someone's physical health.
Yeah, I'd like to address first the statistics, because I'm talking pre-COVID. The statistics were 1 out of 4 individuals diagnosed with a mental health disorder. That being not including the ones that are undiagnosed. So that's pretty high statistics. And the number 1 mental health challenge would be anxiety. The second would be depression. So, we're starting out with just those statistics in the individuals that are involved in the first place. That's number 1. It's important to understand the adrenal gland response. The adrenal gland response, they're a little gland that sits on top of the kidneys. We all have it, okay? This is what is referred to as our survival mechanism. Some may be familiar with the fight, flight, or freeze response. And the reason why it's considered our survival mechanism, it never goes away, okay? Because it alerts us to some type of threat or some type of danger. And we can go immediately from like a 0 to a 10 when we're getting this threat or this danger. Now, when people are coming into, the uncertainty of something that's so important in their life, or something that's so unfamiliar to them, that's when we see this adrenal gland response. So that will affect what side of the brain that they are thinking in. So if those stress levels go up very high, they're reacting more on an emotional response, which Larry can get into, than a logical response. And that is where the expertise of the attorneys that are experienced and the mediators that are experienced to help get back to the logical side of the brain where problem solving can take place. Because there is so much time and energy that is in the emotional responses that doesn't understand logic. So that becomes very important. So many times there's the what if. Now the brain doesn't know the difference between what's real and what's not real. So that is why we can go to sleep, we can dream, we can wake up, and we really think that has happened. When you go into the what ifs, it's like, okay, well, what if this happens? You know, immediately you get this stress response and the numbers go up because your body is physically reacting to something that not only has not taken place, but may never take place. And you already have those responses from the adrenal glands, which, you know, your blood pressure goes up, your breathing changes, your ability to think, shake. Some people actually go into panic attacks. And so all those things become very important. In fact, I think stress is the #1 killer because medically, it impacts everything. It impacts people who have diabetes. It impacts people who have blood pressure challenges. But what a lot of people that don't know is there's something that is referred to as somatic responses. And we see this a lot when the anxiety goes up and people deal with pain. And pain is, you know, is a problem. People even who have fibromyalgia, and they may be trying to resolve the pain by taking, you know, pain medications or other things. But somatic responses that can actually bring pain up to a level 10 is treated differently. It's treated with those anti-anxiety de-stressing techniques, not the medications. And it is very amazing to see somatic responses just based on the anxiety. So when you have people that are experienced in this area and can help them bring down these anxiety levels, you have less time wasted, you have better outcomes in their mental and their physical health and in their whole overall experience that you don't want them to wind up being considered trauma. Larry?
No, I'm good. Paul?
So in terms of, so you know, we spoke about the effect of all of this on the litigants, you know, the divorcing parents, you know, but it's you know, it's a family system, right? There's other people here who are involved. And again, I'll target it to you, Joni, but I'm sure that, you know, you'll figure out who can chime in. But from a mental health standpoint, what are some of the stresses and the ongoing or extra stresses that, you know, that affect the child with autism, him or herself, in these types of situations? And maybe you can give a little thought about, like, what maybe, if you have any advice or tips, what parents might be able to do to help diminish that stress, if any.
Okay, well, first of all, before discussing specifically a child with autism, just in general, a child even without autism, it's been recognized in upper court cases in New Jersey and otherwise, and other places outside of New Jersey, that litigation itself can be contrary to the best emotional health and interests of a child. The process itself can be detrimental to a child. So this is why things such as child interviews and psychological evaluations and things of this nature become courts have to be cautious with this stuff. If you have two parents, remember, a child is should be dependent on both parents being essentially his or her role models, his pillars of stability, right? That's what it's supposed to be, at least hypothetically. That's who a child turns to for advice and comfort and everything, especially a younger child. Child with autism is really dependent on that, one would think, hypothetically, because of the additional challenges he or she has to overcome. So when parents are unable or unwilling to adhere to that general proposition and get into an all-out war with each other in court or even out of court, it clearly has a destabilizing potential on the child. When you're talking about a child with autism, the consequences of that can be catastrophic. We know with autism that it's important to get, and there's a major benefit to have an early diagnosis followed with intense, consistent early intervention and a program where everyone's on the same page. That autistic children have extra challenges when there is an inconsistency in approach, when there is a lack of consistency in the schedule, and when there's really a lack of structure. So when two parents, or when their marriage is blowing up and they're separating or separated and they're living in two separate households, and each one has a whole different way of addressing all kinds of things, including the child's autism and autism-related needs, it can only be hurtful to the child for that dynamic to continue. It's working actually against the child's best interest. So you have parents who say, I love my child, I want to do everything I can for my child. I'll go to war for my child. But the child doesn't need a war, you see. The child needs two parents who, even if they don't love each other anymore, can at least coexist and have a unified front in providing, to the reasonable extent possible, for the needs of that child as relating to the autism, which usually includes, logically, some degree of intensity and consistency in whatever programs are being applied to the child, even if it's in two separate homes. It's when the parents can't do that, or sometimes, in my experience, won't do that, even if they can do it because they just can't deal with talking to their ex, that the child sometimes becomes the collateral damage. The child sometimes becomes the real victim in this situation, and then the parents have an even bigger problem down the line, because instead of the child improving and moving up the steps in terms of hopefully mainstreaming to an independent life, instead he's caught in the middle of stagnation or possibly regression because the parents can't get on the same page, are unable or unwilling to get on the same page. And the joke of it is that very often the parents can get on the same page, and there are reasons why they can't, other than one parent is a bad person. While each parent in a divorce may think the other parent is a, quote, bad person, it's pretty unusual when the objective evidence shows that someone is the angel and the other is just the bad person. It's usually, very often, at least, it comes down to a mutual lack of disrespect by each parent for the other, a lack of hearing or being willing to compromise in terms of what the other person may want. And this is why things such as not only mediation, but there's something called co-parenting counseling, which we can talk about in a little bit, which are designed to kind of get the parties to a point where even if they don't love each other anymore or even like each other anymore, they, at least for their child's sake, can work together a little better than they could previously to provide a better life for their child. Otherwise, the child stagnates or regresses. That's terrible for the child. It's also terrible for the parents, because now they're going to be having to spend more money and time and energies on extra services down the line that could have been avoided had everyone just tried to do something a little cooperative earlier on, like at the start of their separation or divorce. Yes.
Yeah, and I just want to add to the concerns with the intensity and consistency, for instance. You know, like Larry had mentioned previously, sometimes there's simply a difference in perception. And that leads to a difference in cooperation. And many times we'll go to the IEPs, if there's an IEP, and we'll go back to, you know, using that as a baseline as a plan of care. However, we have to remember that when there's going to be separation of family, that the roles are going to be changed in some fashion. And if one parent was taking on more of a role where they were more involved, when you're talking about parenting time, now you have another parent that is being with the child, you know, for maybe a couple days even at a time, that now has to take on a role that they may not be well versed in. And what happens in mediation, there can be part of an agreement that there's going to be more of a agreement to attend trainings to know what exactly it is that their role, their change in role is now going to require to continue with that retraining of that brain, that the intensity and the consistency to set up a successful transition. Because what I've seen in many cases where we're trying to teach a skill to a particular child that has autism, that we want to use certain motivators that will only be used for a specific task accomplishment. And then if another parent breaks that and gives that motivator to that child, then you've just lost all the motivation in working towards that skill. So why should they work, at doing something that may be a little bit challenging for them when they can just go somewhere else and get it for not, doing anything? So that becomes very important in prevention of the lack, the regression, and also in mastery of a skill where you're getting that across all environments. Now, the other thing that I want to touch upon is the effects of parents fighting. I'm going to give you the link to a video that when I watch it, it still brings tears to my eyes. And it's called, it's at www.pointcvideo.com. And it's done in a fable form. And it really explains the overview, which I think that if every parent's even watched that before they came into either, the court or the mediation, it'll strike a little chord with them too. But as far as the effects, Paul, we see increased stress levels. We see fear of the unknown. We see, a lack of coping skills. Children don't have, the coping skills like, people that are older that have developed. There's oftentimes misinterpretations. So they feel torn or they feel lost. Sometimes we see them feeling guilty. And, some children may feel like they don't have anyone to turn to and they'll isolate. We may see, especially in autistic children, we may see the attention-seeking behavior, and we may see, more of that acting out, more self-stimulatory responses, perseveration of thoughts, even changes in eating that might be a challenge to begin with. We see declines in progress in school work. And also, especially with people who are out in the community, they may be bringing the misinterpretations through conversations in the community. So whether it be friends, parents, teachers. So now you have this whole, misperception and gossip world going on. But the thing that is really important that many people may not be focused on, and of course I am, is that all this confusion and overload can lead to feelings of helplessness and hopelessness. And these feelings of helplessness and hopelessness in children not only can lead to hospitalizations. However, I don't think people are aware how many even 10-year-olds have taken their life, who have had suicidal thoughts and have taken their life. And this is how serious all this stress can amount to. Now, when you get into the siblings, there might be some resentment. There might be some need to be overprotective. And they can digress, again, with the misperceptions, the lack of understanding, the brain going into the what ifs, provoking that fear. And when it comes to part of the mediation, there may be extra reassurances that are needed, or also when developing parental time, that there might be some alone time even needed for the child, you know, the sibling of somebody with autism.
When I was on the bench, I interviewed a lot of children. And when I interviewed children in custody cases and parenting cases, I can say that while each child was different, each child is unique, overwhelmingly, when these children were interviewed, and they were all interviewed outside the presence of either parent, it's what's called the closed courtroom, the common thread that would run over and over again in their comments were, number one, that they resented both parents for having put them in this situation. They did not want to take sides. They felt that they were being pushed to take sides. Whatever they told their parent in their kitchen was not necessarily what they really meant, but that they felt they had to say to appease one parent or the other. The older children in particular, teens and even preteens, knew they would say this. They were pretty astute. They would say that the money which is being spent on the court case is money which could have been spent on them, on a future car or college or braces or whatever it may be. And so it was plainly obvious that when parents were, you know, thinking, oh, I'm fighting for my child, that, as I said earlier, there was collateral damage taking place. Sometimes when I would tell the parents after the interview was done, at some later date, a summary of what the children said, it would actually help settle the case in a lot of instances. It's kind of like a wake-up call. But in the context of mediation, I will say this. While every case is different and people are different, particularly with children with autism in these types of cases that I've mediated, what I find is that, in general, the issues themselves are not that complex. What makes the case complex is the dynamic or dysfunction between the parties themselves. If you have two functional people, you could take the most complex case in the world and wrap it up maybe in a short period of time. You have two people who have, you know, grievances with each other, and that's their main focus. They could be fighting over the Christmas or Hanukkah decorations and spend a year doing that, just because it's the fight. Now, what it comes down to is, I find very often with children with parents and children with autism in mediation is, as I said earlier, it's not that anyone's the bad person necessarily, although there are some cases where it's pretty obvious someone's doing something they shouldn't. But in general, that's not what it is. What it is nobody wants their ex to tell them what to do. That's what it is. That's what it comes down to. In other words, if somebody hears from a therapist, from a third person, that the child with autism could benefit from X, Y, and Z, from this type of program, or this, or don't feed them this, or don't let them watch too much TV, they will be much more receptive to it than if their ex is not only asking them not to do that, but telling them not to do that, and basically trying to, quote, control them, at least from the other side's perception. And of course, this happens sometimes, and sometimes it happens not because anyone's trying to necessarily control. Sometimes they really have the best interest of the child at heart, but the way it's heard, the way it's seen by the other side is what sometimes amounts to, from their perception, disrespect. So if parties, and we spend some time in the mediation talking about this, just laying the groundwork, because what makes for a successful mediation and hopefully a successful settlement of a case and kind of a new chapter in the parties' lives and the child's lives as divorced or separated parents who can function, is to be able to deal with each other in a different way than perhaps they didn't even realize they were dealing with, in a very negative way beforehand, which was not going to result in any kind of cooperation, but result in resentment. So once people start dealing in that fashion and they stop writing long-winded, capital-lettered emails to each other saying how terrible the other person is, and start really taking a different approach, sometimes with the assistance, as I mentioned earlier, a co-parenting counselor, that's another type of professional which some people benefit from and can use, it can help the child. It can help the child with autism. How? First of all, there's some peace going on, at least an attempted peace, number one, instead of an ongoing war. Number two, if people can better communicate with each other, regardless of how unsuccessful that may have been in the past, now you have a chance to focus on the specific needs of the child, consistent with the instructions of whether it's a behavioral therapist, or any other professional who is essentially the quarterback, the professional quarterback for the child's long-range plan. With the Zoom situation, it makes this even easier, because what happens is you could arrange, as part of a settlement, for example, there's a dispute over how services are being administered or inconsistency in each house. If part of the settlement is that the therapist meets with both parents together on Zoom, hypothetically, once a week or once every 2 weeks, whatever it may be, now the parents are hearing this from the quarterback. They're hearing this from the professional. They're not being told what to do from their ex. They're both listening and hearing the same thing at the same time, instead of each one hearing only what they want to hear, or perhaps what they think they're hearing, and having kind of a mishap. Zoom can be recorded. So if the parties agree, the therapist's instructions, when the therapist is instructing on things such as generalization and reinforcement and things of that nature, now they can go back and listen. They can be on the same page. You can set basically milestones, almost like your own IEP in a way, only not necessarily in the school, although it should be consistent, obviously, with whatever you're agreeing with the school, so that there is a complete consistency of approach. If it's not working out for whatever reason, if the child is still having issues or is not progressing, it may be independent of the parents. It may not be independent of the parents. But if the therapist is indicating, look, from my feedback, there's, I think the dad could be doing more of this, or mom could be doing less of that, then you adjust. You could have, if you needed it, follow-up mediation sessions without having to refile in court. Because if it's part of your agreement that you're going to continue in this process, periodic reviews, that type of thing, unless both parties agree everything's working out fine and you don't need those reviews, you've got it built in, hopefully, for not only short-term success, but long-term success. Nothing's guaranteed, but at least there's a plan. At least there's a working plan in place. It's not being crippled by parental dysfunction. And if one parent or the other continues to act in a dysfunctional way, can it demolish the whole process? It can. But there are more than enough cases where that does not happen, where everybody just kind of, gets with the program, forget about the past to some degree and moves forward. And that should be the focus in any case involving a child with autism, regardless of whether the issues are custody and parenting time, or support, or special needs trust, or anything else which may come up. You got to start with a solid foundation and build upward from there.
And just shortly to add to that, what becomes very important is, what is the communication to the child study team or to the school, to the teacher, if they are school aged? Because if they're getting missed messages, if one's saying one thing and somebody else is saying the other, this could be very compromising and detrimental to the child. Because in my experience, a lot of them will go to the lesser demand in the school, or the less costly, in the school district. In some cases, than what the needs are. So there has to be a consistency in that reporting, and there can be an agreement of if there is a behavioral therapist involved or a third party involved like that, that maybe they act as the communicator.
But the worst thing is, one of the worst things is when one parent undermines the other parent in an IEP meeting or in a child study meeting. I mean, that is, and this happens, and it happens because one parent or the other, their focus is on the fight. Their focus is on the hostility between the parents, without understanding just how detrimental and inconsistent that can be. Now, what's the school district supposed to do? One parent says one thing, one says another. It's possible they may take the path of least resistance. It's not automatic, but maybe. If you got one parent saying, there's nothing wrong with my son, there's nothing wrong with my daughter, they don't even have autism, we don't need services. And the school district hears this, all right, maybe they don't need services. And so you got to be, and there may be cases where a child really doesn't need services, but you have to investigate. So in the context of whether it's in a mediation or a settlement conference or even in a court process, I mean, when I was on the bench, I'd have this situation. People would come in and one parent would say, my child has autism, they need X, Y, and Z. The other parent would say, there's nothing wrong, my child doesn't have autism, etc. And no one even got an evaluation. They're just taking their positions, they know everything, right? But they didn't do the obvious thing, get an evaluation. I would actually order an evaluation. Let's find out first. This is something you shouldn't need a court to do, or even a mediator to do, quite frankly, but sometimes you do. Again, not because it's required, but because the parental dysfunction and breakdown in communication causes that situation. So people who are more willing to work with each other or at least are willing to attempt to start a new leaf and work with each other, probably have a better shot at getting some mutual cooperation and some positive results than people who are so busy fighting with their ex and, you know, complaining about what a terrible person he or she is, that they're spending all their time and money and energies misfocused and misdirected from where they really would be better applied to their child's needs.
And denial or minimizing can actually be also a very unhealthy coping mechanism when it's done a long time. And we see that, you know, many times within parents, and, you know, they're just denying or minimizing it altogether. Or sometimes people don't see it as a problem because the apple doesn't fall too far from the tree. You know, sometimes, you know, the parent has a diagnosis and they're not even aware of it and they don't see it as an issue. So sometimes that crops up too.
That's all very great. That was, I mean, there was a lot there in that dialogue. So appreciate that. And there are some questions that are coming in from participants here, and they're very good. So I'm going to get to them in a second, but I do want to ask you guys to talk a little bit about, before I get to them, because I think they relate to what you have been saying, and I think they're going to relate in some ways to the questions that are coming in from the folks here, is you both have mentioned co-parent counseling, and, you know, I'm aware of things that exist like parent coordinators and so forth. And I was wondering if you guys could maybe speak to what those two kind of roles are, what the differences are, and like how they can be useful to the family and everyone's mental health.
Yes. Okay. Co-parenting counseling and parenting coordinating are to some degree they're similar, but they're very different as well. Co-parenting counseling is essentially the opposite of marriage counseling. Marriage counseling, people are going to a counselor in private, in confidence, and seeing if they could save their marriage. Co-parenting counseling, the marriage is already done. You're already divorced or divorcing, or if you were never married and separated, there is nothing to save anymore. You're moving on from that relationship. But as parents, you still have to learn to work together a little bit as separated or divorced entities for the sake of the child. You know, the ironic thing in our law, under New Jersey law, the most common cause of action for divorce is the no-fault grounds of what they call irreconcilable differences. People, they go to the court, they say, we have irreconcilable differences. We can't agree on anything, therefore we should get a divorce. And you usually get a divorce. Also under the law, there's a strong public policy favoring, not in every case, but generally favoring what they call joint legal custody, which means regardless of where the child lives, primarily, both parents have a right to participate in the major medical, educational, health-related decisions of the child's life. So if you look at the definition of custody, you know, in terms of what a court looks for, one of the first things is ability to communicate and cooperate. So it's somewhat ironic that a court is going to divorce people who have irreconcilable differences, the inability to communicate with each other, and send them out as presumed co-parents with an obligation to communicate and cooperate with each other. So how does that happen? Piece of paper may say that's what you're supposed to do, but that doesn't mean that's what's going to really happen. So co-parenting counseling is kind of a niche which has developed really over the past 20 years, more and more, where a trained therapist or counselor with education and experience in this area works on trying to improve the foundation between the separated or divorced parents so that you can communicate and cooperate better on child-related issues. This can be really important if you have a child with special needs for obvious reasons. Things pop up all the time. So, you know, you're not going to just magically say, oh, let's get along with my ex, you know, we're friends now, especially if you're carrying all this resentment from whatever happened, which broke up the marriage in the first place. But you need to. For the child's sake, to some degree, you need to be able to do that if you're really putting the child first and you second, instead of you first and the child second. So both parents need to do that. So co-parenting counseling, much like mediation, is done over a series. For example, you can agree, and I've done this in mediations, the parties have agreed as part of the ongoing mediation process. They agree. They're going to go to a series of, for example, 10 sessions with a co-parenting counselor. Usually the first session is with one parent, the second session with the second parent, and by the third session, you're kind of meeting together and then you kind of go back and forth. The difference between mediation and co-parenting counseling, generally, the mediator's working out the legal issues and the structure for everything. The co-parenting counselor is working on your dysfunction, working on, regardless of whose fault it is, trying to get, meaning the relationship's dysfunction, to get you to a point where you can be cooperative. You know, I used to tell people in court, there are countries who've been at war with each other for 5,000 years that make peace treaties. Why can't the two of you, if the cause is right, meaning your child? And the answer is they can. Most people can. They just don't want to, or they can't bring themselves to do it. So a co-parenting counselor helps you with that. And like mediation, it's confidential. The co-parenting counselor does not do an evaluation. The co-parenting counselor cannot be called into court to testify against one party or the other. And very often it's done in conjunction with the mediation. Sometimes people say at the end of the sessions, I wish we would have done this years ago. And they just didn't know about it. And other times they say, let's do some more sessions. Now, in other cases, one side or the other, they don't want to do anymore, which is fine. You're not obligated to if they've done whatever they've agreed to. But some won't even, they set it up to fail. They come to the first session, and the minute they hear the co-parenting counselor say something that's positive about the ex, they're walking out. You favor the other side, etc. So there has to be a willingness for both sides to, at the very least, even though the content of the co-parenting counseling is confidential, the attendance can be verified, that you actually went to the session, that you sat through the whole thing. And as Joni said, with Zoom now, you can do that too. If you find a co-parenting counselor who does a Zoom co-parenting counseling, to my understanding, they're more and more doing this, then you don't have to have the pressure or stress of sitting literally in the same room with someone who you don't really like at that moment. Now, so that's co-parenting counseling. And very often it's voluntary, but you have to understand also a court can order it. There's a case called Madison versus Davis, a reported opinion, which indicates that a court can order co-parenting counseling. And I'm familiar with the case because I wrote the case. But it was a case where there were two parents. It was not a child with autism, but they were having a feud over their 4-year-old. And I ordered them to go into co-parenting counseling. So a court might require you to do that anyway at some point. So you might want to think about perhaps doing that earlier on. And you might actually get some benefit out of it. Some people say, I don't need counseling. It's all his or her fault. But it's usually helpful if both parties can participate to try to mutually get to a point where you can have a better launch pad. Parenting coordinating is a little different. A parenting coordinator is not a co-parenting counselor. A parenting coordinator is someone chosen by both sides to essentially make decisions without the parties going back to court on I'm going to say kind of more routine issues. You can't make somebody a private judge, basically, in your case, unless you both agree to arbitration, which is a whole different story. But lots of people pick a parenting coordinator. So, like, for example, if they're having ongoing issues as to who's doing the pickup or drop-off the day before Thanksgiving, or, whether the child is going to play football versus basketball, those types of things. Vacation scheduling, because vacation scheduling can be a pretty big issue when you have an ESY, an extended school year program, should that be interrupted for a parent to go away on vacation, that kind of thing. So lots of people use parenting coordinators too. That's usually not going to be compelled by a court. There was a pilot program to have parenting coordinators, and it was not renewed. So in general, I don't think you're going to find a court order a parenting coordinator, but some people agree to have one because they find it's good to have somebody in place on a just-in-case basis. Kind of like a fire extinguisher, break glass when needed, break glass and take out your parenting coordinator, and then you have somebody to try to resolve your differences. Yeah, John.
Yeah, what I like to always add is when I speak to individuals, it'll be, is the way you're responding getting you the end result that you're looking for? Right. And if they say no, then something needs to change. What I go from there is I explain very simply that we are not born with knowledge. We're born with the ability to think. We're born with the ability to learn. But if we have never been shown something, how could we possibly know about it? We wouldn't. And some people just do not possess the skills. We were not, born with this manual that told us how to be, a good parent or how to deal with autism. And when I go into into a way where somebody feels like less that they're being viewed and have to be put on the defensive, and then they shut down to, effective listening. All those strategies become very, very helpful in what my experience has been.
So how does, I'm going to take a couple of questions from the group. Let's do the last one first, because it's very timely. How do you find a parenting counselor?
Well,
If it's not been
there are a
ordered
few
by-
ways. There are a few ways you can do it, but very often I tell people in mediation when this issue comes up, a good starting place may be to look on psychology.com. I can't vouch for any one specific person, but I can tell you that they have a pretty good website. You type in your location and you will get the names of various people and their specialties or their focus in practice. So many people have gotten co-parenting counselors from that site. In terms of parenting coordinators, keep in mind that a parenting coordinator does not have to be a mental health professional. It can be, but doesn't have to be. Sometimes you pick a lawyer, sometimes you pick a social worker, whatever the case may be. Parenting coordinators, some people do both. Some mental health professionals do both. And you'll see on psychology.com, you find out if they do both services, you figure out which one both sides are more interested in retaining. There could be some issues as to whether one person should be doing both, because there could be some conflict issues there if you're both a counselor and the coordinator. So that you got to be really, I think, you got to be cautious about it, and you ask the professional involved. But another place to get a parenting coordinator from, if you call your local bar association, every courthouse, every superior court courthouse has a bar association and an office. So for example, if you're in Somerset County, you call the Somerset County Bar Association at the court and say you need a referral for a parenting coordinator, and you should be able to find someone. But with a child with autism, quite frankly, if you're going to pick a parenting coordinator, you want to pick someone who not only has experience, but has experience coordinating a case with a child with autism. And of course, there's such a large spectrum with autism, going from severe autism to mild Asperger's and other things, that the needs of a child may be different, but you want to get somebody who has some degree of experience as a parenting coordinator. Very often, you have a special education teacher or someone who's doing, maybe some private work on the side, that type of thing. That might be somebody who does parenting coordinating. In my view, and every case is different, but just personally, I think it's better to start, if there's a difficult relationship between two parents, to start with the co-parenting counseling before the parenting coordinating, because the co-parenting counseling, you're working on calming things down. If you're starting first with the parenting coordinator, you've never addressed that issue, and everything is just, let's see what the coordinator says. Before you know it, you're spending an outrageous amount of money contacting the coordinator every 5 minutes because you've never addressed the underlying dysfunction that makes the relationship bad. The truth of the matter is there are many, many people, and I've seen it. I could be a witness to this, I've seen it over and over again where people start off very contentious, very litigious, and somewhere down the line, they've found a peace with each other, either because it cost too much or they got a little wiser, a little more mature. They saw, like Joni said, is it working for you? Does the fight working for you? Usually it doesn't. You ask anyone who's been to trial whether they thought it was worth it, and I kind of suspect that the majority of them will say it was not, but that they had no choice. The truth of the matter is you do have a choice. At least you have other options to try to avoid trial. A trial should be your last resort usually, not a first resort, unless it's an emergency situation and you have no choice but to go to court quickly.
So here's a time, and by the way, I'll echo that with respect to going to trial. I think I can count on one hand how many times going to trial and taking it to conclusion has probably been worth it. And I'm talking about in the special ed context and so forth, where the parent believes that the whole thing was worth it, and so it is rare. But we have about 10 minutes or so left, and I want to take a couple questions. This one's very timely, and obviously it's born out of current events. Person is asking, can a parent refuse to take their child for shared parenting time because they are using COVID as an excuse? The mom apparently gets no child support because of agreed shared parenting time. Mom has had the child full-time since March. dad refuses to do anything, and there was a follow-up statement that says the dad refuses to communicate with the mom at all. So there's no like controversy there or dysfunction there at all, right? In terms of the relationship. And
Yeah. Welcome
so
to
how do you,
divorce.
welcome to divorce. So that's a timing one, and I've read about this is a little bit in the law journal. Again, I don't practice family law, but I've read about this issue coming up in the law journal. Comes
Yeah.
up in the law journal. So what are you guys' thoughts on that? And maybe you guys can give some thoughts about how to address it.
All right, COVID, COVID's an interesting issue. Obviously, nobody saw it coming, and it hit everybody all at once. Both the bench as well as the bar, association have been grappling with this issue, not only in New Jersey, but in really in all 50 states. When COVID first broke, really in March and April, when the shutdown orders, stay-at-home orders started occurring, there was no structure to any of this stuff really at all. And so people were, keeping their kids or, refusing to let their kids go anywhere, even to the other parent, and it would sometimes cause some issues. And there was no real precedent for courts to follow. There was no body of law. The courts like to look to see what prior courts have done, precedent, judicial precedent is what they call it. And obviously there wasn't much of that. Well, there was some analogous. When I was on the bench during Hurricane Sandy in New Jersey, we had kind of similar situations, but it was much more regional, and more temporary, I would say, to some degree. But in any event, while to my knowledge, there are no formal New Jersey higher court opinions that deal with this issue yet, because it's such a new issue. As far as the courts are concerned, 7 months, which is since March, is not a long time for judicial opinions. That sometimes it takes years for those to develop. But in general, the concept is essentially that parenting time should continue. COVID is not a basis to violate an existing court order for parenting time, unless you've got substantial evidence demonstrating that that child will be impacted by what is taking place. It can't just be, well, there's COVID, so now I'm ignoring the child's right to have a relationship with both parents. Now, in the situation which was described, and I want to be clear, I want to give a little disclaimer here. I'm not giving legal advice on any specific factual circumstances of anybody, but if you're talking about a hypothetical general case where another parent is not contacting them, not communicating with them, not talking with them, that's the type of issue, with or without COVID, where, a court may have to take a look at that if the parties can't resolve it between themselves, because having a right to parenting time under joint custody, if the order says joint custody, that would also involve, as I said earlier, the ability to communicate and cooperate with each other. It says right in the statute. And so if one parent is refusing to have any contact at all and there's no basis for that, and they're not telling them, what the arrangements are, you have a child with autism, what are going to be, are there certain eating restrictions? Are there certain therapeutic requirements? It may need to be addressed. Now, can it be addressed in mediation? Maybe. Can it be addressed in a settlement conference? Maybe, or in co-parenting counseling. But if one side is refusing to have any contact at all with the other side, and that contact is necessary to facilitate the best interests of the child, consistent with the parenting schedule, and especially given COVID concerns, that issue may have to be brought to the attention of a court. Hopefully, it doesn't get that far. Hopefully, the parties, either directly or through counsel, as long as there's no restraining order in place, or through mediation, can try to resolve it. But if not, sometimes a court may have to take a look at it. But COVID in and of itself, the fact that there's COVID out there, and given the fact that in New Jersey, the governor has gotten us, it's gone from phase 1 to phase 2 to phase 3, there's kind of a lessening of the restrictions. It's even less likely, I believe, that COVID's going to be a basis to withhold parenting time than it would have been back in March or April when everything first broke loose.
Talk about the order to show cause with the financial changes, because she has all the time. So the child support. Isn't that
No.
That was part of the question?
No.
Well, no, the person said that there's no child support in this particular instance,
right?
Because I'm going to presume the person says because of the child, the shared parenting time between. So I don't know if they have exactly equal parenting time.
Yeah, I'm not sure, because I thought the question was about COVID. But the
Well, it was.
Oh.
It says, the dad's refusing to take kid because of COVID, but dad's not paying child support because of the, I guess,
well, whether
the
that's
existing parenting time order.
right. If someone's not paying child support with or without COVID, there's obviously an issue there. If there's a court order for child support and it's not being paid. Now, in some cases, someone's not paying child support and it's already gone to court. And the court has said, well, they've either suspended for whatever reason child support or reduced it or, arrears only or whatever it may be. If it's already gone to court, you're kind of stuck with that order unless you appeal that order. If in fact it hasn't gone to court and someone isn't paying child support, whether it's during COVID or not, there is an issue in terms of enforcing a child support obligation, obviously. And so sometimes that's worked out in mediation. We were just mediating one a couple of days ago on that. And other times, if it can't be worked out, it may require a court to get involved. The situation with COVID, though, is that, for a while there, courts were really shut down. Then they slowly started to open online. They're just now gradually getting back to an in-person type situation. And also, even if the courts can, hear your case immediately, depending on the situation, some people have legitimately lost their livelihoods over COVID. If you were a server in a restaurant and you've lost your job and that's all you've ever done, and you had a prior child support obligation, it could be the basis for a court to modify either temporarily or otherwise your support obligation, at least until you have some time to try to find replacement employment. So COVID affected a lot of people financially, a lot of people who were supporting children, a lot of people who were paying alimony, and there's really no structure in how a court is going to deal with those issues established just yet. They're kind of doing them as they come up, depending on what the specific factual circumstances are. So is it possible COVID could result in some kind of modification of parenting time in some fashion on a temporary basis? It's possible. Is it possible COVID could result in some modification of a support structure? It's possible, but there's no way to predict with certainty what it would be. This is one of the reasons why you want to try to settle the case, either in a settlement conference, mediation, or otherwise, because there is no predictability to these issues. Nobody could tell you, I don't know, it doesn't matter who your attorney or judge is, nobody could tell you with a crystal ball what exactly is going to happen if you bring that case to court, other than you are surrendering control over it to a court and just kind of hoping everything's going to work out the way you'd like it to, which doesn't always happen, as I said earlier.
It certainly sounds like this particular situation probably would benefit from, some folks going back and talking to their matrimonial attorneys and perhaps going back to the mediation table. Right, Judge? You can always go, and Joni, I don't know if you recommend it, if parents can't get along, sometimes maybe you need to go back to the mediation table and hammer out some differences that may have cropped up post-divorce. Is that a possibility, and does it happen?
Yeah.
Yeah, well, I think that if somebody's not talking to somebody, you might have to start with the court and then go to the mediation.
That's a very good point. You might have to have a person in the black room to order you to talk.
Right. Although sometimes the opposite does occur. For example, if in fact one person's not talking to the other, but they have a lawyer. So sometimes your attorney contacts their lawyer and then you set up a settlement conference or a mediation. Right. So but it's not necessarily, a lot of times people aren't talking and they have their own reasons, right or wrong, why they've taken that position. They say they're being harassed or abused by the other side. They say the other side has done X, Y, and Z to them, and everyone's mad at each other. So, I wouldn't say you automatically have to go to court because the other side's not talking to you, but you first can try to make an attempt to try alternate dispute resolution. If they're still not responsive, if they're not willing to voluntarily participate in something like that, as I said before, sometimes court is a last resort, and you can request in court, among other things, for the parties to be ordered to go to mediation. Sometimes that's part of an application as well in certain cases.
Actually, it's not an uncommon one, even in my experience. Oftentimes in guardianship proceedings, when you have a contested guardianship, that's the family law equivalent of what sometimes I get involved in a guardianship proceeding. You go to court, somebody's got to file the request to become the guardian, but you ask the judge in the guardianship matter, this case might, how it works. Lawyers send signals. This case might benefit from mediation, Your Honor, right? And that is like your fastest ticket out of the courtroom, because the judge is really happy to give you that ticket, that order. Go to mediation for 6 hours or 8 hours or 2 sessions or whatever it is, and then come back and talk to me if you still need help.
And you're right, by the way, with the guardianships, what happens is when child turns over 18, you're really not talking about custody of the child anymore. You're talking about a child with developmental disabilities. Now you're talking about guardianship. And for an adult, sometimes guardianship. And sometimes you have these disputes between family members. Sometimes they're not even divorcing. Sometimes it's between, blood relatives sometimes. And it even can happen with a senior, like a mother or father who has Alzheimer's, and there's a dispute between family members as to, where mom's going to go or dad's going to go. So mediation sometimes can assist those parties as well. It's not necessarily all limited to divorce or separation.
Absolutely. Or sometimes I've had a couple of cases over the years, actually 2 in the past 18 months, where you have an adult child with autism and you have parents who are gone and the adult siblings arguing about some of the very issues the two of you touched on. Right. He's not that bad. Or what are you kidding me? Who are you looking at? And, they have this cross understanding of what their siblings' abilities and limitations really are.
And you find at the start of the mediation very often that the parties have never really even talked to each other directly about this, other than perhaps in some kind of a yelling or screaming match. And very often, the mediation is the first time that the parties have been willing to sit down in the same place or at the same time to actually have a discussion. And the mediator, in a way, functions almost like a referee in a boxing match, in a way. I mean, it's really true. In order to ensure that the program stays on track and everyone's working towards the same end, and that it's done fairly, and it's not one side just screaming over the other and demanding, and basically they have their say and they also have your say, because that's not mediation. That's not even a discussion. That's just one side trying to steamroll over the other side, which almost never works.
Right. And I don't know which one of you said it, but I did chuckle pretty hard when you talked about the email, in all caps, so a lot of times that's the only way that folks have communicated. And Joni, I'm sure you would probably agree that's not really communication in the sense of sitting down across the table and trying to find some common ground on some issues, if it's achievable.
When every word in a single spaced 1-page email is capitalized, there's a problem.
That's a good rule of thumb to live by.
You're virtually scream shouting is what you're doing.
Right, exactly. And it's unfortunately, well, in my experience, no matter, if I've got the guy who's sent the email in all caps, or if I have the person who received the email in all caps, it generally doesn't go well for the person who sent the email in all caps, right? It generally, that's not looked upon favorably. And sometimes you get both of them sending, emails and all, those hot, hostile, angry, over the top emails. They're generally not productive. And that goes to Joni's point. Like, if this is if it's not getting you the result you want, like, maybe you want to change something.
Right. It's never productive. Has anyone ever received an email like that and taken it seriously or read it? You might read one sentence of it and then click it off, say, I'm not tolerating this. It doesn't work. And so if it doesn't work, why are you spinning your wheels? It makes things worse, because now you're throwing basically gasoline on a fire for no reason other than you're just venting.
And Paul, some people really need skill building on how to change, because some people don't know how to change. So they have to go, to learn about the stages of changing.
Yeah. I mean, we've all been in hostile disputes with somebody else at one point. We don't get out of life without being, hopefully it's not your spouse. My advice to clients, and I've even done this myself sometimes when I'm, very angry, I may author that email that's in all caps, but I've learned over the years that I just end up sending it to myself. Right? And I feel better about having written it. I feel better about having hit the send button.
Right.
But it does no damage.
But Paul, you know what they used to say, the good thing about snail mail before email was after you wrote a hostile letter, you'd still have time to think about it, because you'd have to go and put a stamp on it or make a copy and bring it to the post office. Now, there's no filter. You're just typing anything, you hit the send button. And we've all sent things at one point or another that we've regretted sending, obviously, and that happens sometimes. But in a court case, every little thing gets magnified. And you're absolutely right. If you're sending hostile emails with all capital letters and underlined, it's not going to be looked at in a favorable way in all likelihood, especially if that's your common methodology of communicating.
And Larry has a rule of thumb. If he's writing an email, he will not send it for 24 hours. He'll reread it 24 hours later.
That's true. Well, not
That's a good
every
rule.
emaam.
Not everyone, but the
No,
ones
yeah.
that, you know, might be a little bit more emotional.
Right. It also helps
Yeah.
spell check better that way too. You have a
Grammar
clearer
and
mind,
punctuation.
maybe with a
Yeah.
glass of wine. You know,
Right.
you just got to set yourself up for success, as they say.
Exactly. Well, guys, we've reached the end of our time, and as always, you guys are great presenters, and I haven't seen you guys present together in a while, and I miss it. You guys did a great job, both of you, and I really appreciate both of your expertise and different perspectives and so forth. And
Well, we
and thank you
appreciate
again for the
you
conference.
inviting us, and best of luck to everybody who's participated today. I hear your conference is doing tremendous, Paul, so congratulations on that. And it was a pleasure participating.
All right, guys. We'll see you down the road. Enjoy the rest of your Saturday.
Thank
Take care,
you,
you too. Take care,
Get
everyone. Bye-bye.
outside.
Bye.
Bye now.
Thank you for watching this encore presentation from the Fall 2020 Hinkle, Pryor and Fisher Parent Empowerment Conference. With 24 other presentations to view, there is plenty of additional information to help you become empowered. As a reminder, the information contained in this video is not a substitute for individual legal advice and does not create an attorney-client relationship. Copyright 2020 Hinkle, Pryor and Fisher, PC, Attorneys at Law. All rights reserved.